the daily mass transit. The booty bandit, the booty bandit, the kid do is bandit. Can you feel it?
Can you
My
feel it?
fucking sensation. Do the bumpers on your station. If not, stop and grab the horn. Hey,
Not stopping. Play that new thing to
on
thing.
and on to the break of dawn.
To
And
the
I don't wanna
break.
be right if hip hop wrong. So I love
Hip-hop
the dog
wrong.
and BAT.
Hold on. He don't want to be right if hip-hop wrong. Do y'all understand what he... If loving you is wrong, I don't want... That's what he was playing on with them words right there. Ladies and gentlemen, gentlemen and ladies and gents, had to redo this one because it was absolutely necessary. Ladies and gentlemen, gentlemen and ladies and gents, that fool is a genius. I mean, he is a genius. Hey, he's a freaking genius. I ain't no freak. Don't be calling me no freak, ignorant mother. I didn't mean it like that. I was just saying, it wasn't, I'm sorry. It's all right. Hey, Betty, that boy's a genius. You know, he's a genius. I done told y'all he's a genius. He's been a genius for a long time. He came up with the IMAG. I am a genius. IMAG. That's right, not IMAX, IMAG. I am a genius. He's a genius. I know he is. He's been a genius for a long time. Hey, Robert. Hey, Robert. Boy's a genius. What you mean you already knew? You didn't know until I told you he was a genius. Oh, my stars. That boy is just, he is, oh, Lord, he's just such a genius. Ladies and gentlemen, you heard it. I's a genius. And I'm not a genius because you want me to be a genius. I'm not a genius because I said I'm a genius. I'm a genius because they didn't see me coming. Now, I'm going to explain this. I told you I believe in this group called the 14 percenters. I believe that I am one of those members. There's 14% of this population that is completely unique. They're different from everyone else. They don't act like anyone else. They cannot be compared to anyone else. Well, you act like my cousin Robert. You know, that hit boy never been right in the head since the day he was born. They dropped him 18 different times. The doctor just kept letting him slip out his hand because of all the blood and everything. Just kept slipping out his hand. So that boy ain't just, you just like him? Your mama. All right. Well, my mama's just like him too because they did the same thing to her. That's why they're two birds of a feather. And you like the third feather bird. Your mama and your daddy. Ladies and gentlemen, 14% of the population cannot be coerced, cannot be made to do anything, but they also don't think like everybody else. They don't think outside the box. They don't think inside the box. They think without the box. There is no box. Just like there is no spoon, there is no box. If you think outside or within the box, you are still thinking in a confined space. And if you think outside the box, that means you're not considering what's in the box. So if you're not considering what's in the box, that means you don't consider everything. If you didn't understand that, I can't explain it to you. But didn't you just try to explain it? That's right, and that's why I said if you didn't understand it, I can't explain it. Oh, okay, I understand now. So, I promise you, if you don't get this, then it's not meant for you to get, and there's nothing I can do to prove it to you. So, let me make sure you understand how much of a genius I am. All praises due to my God Jehovah, because that's where my genius comes from. Ladies and gentlemen, this is Code of Federal Regulations 363.6. Want y'all to pay attention. Code of Federal Regulations, Title 31, 363.6. It's right here. See 363.6, and this is Title 31 CFR 363.6. Want you just to focus on 363.6. Why is 363.6 so important? Hey, Boris, if it was not for Boris, okay, and him giving the information to Francis, and my receiving it, I would never be on this tip. So, Boris, Mr. I am some dude, I give you the credit. But I'm going to show you something that we all missed because we were looking at it from the wrong angle. Ladies and gentlemen, it depends on your perspective. And many of you are going to look at this, I already read that. I already know what it talks about. No, you don't. I'm going to correct you. Ladies and gentlemen, the courts are dealing with trust. How do we prove The courts are dealing with trust. Sorry, there was something in the air, a little speck of dust. You know that we are here, we are here, we are here. So I blew it to make sure it wasn't on a spider web, because I don't like spider webs. You know, spiders are okay, but their webs, that stuff is so irritating. I can deal with a spider crawling on me because all I do is like that and snap it, and he's gone. You know, he's like splat and no more spider. Okay, but anyway, the web, you can't just splat a web because now it gets all over the place. So you got to fight with the web, and I don't like web fighting. I leave that up to the man with the spider, you know, and because he does whatever a spider can, you know. All right, ladies and gentlemen, let me give you a different angle to look at this. I promise you it's the only angle you should have been looking at it from the very beginning, because this explains everything that's going on. This explains everything that's going on in the courtroom. This explains how to respond to the court. Look, in the court, you tell them, hey, excuse me, you're dealing with a trust here. Well, what do you mean? You don't see no trust. The trust is all around us. This is all about trust and equity. Come on now. Okay, then fine. Let's pull up 31 CFR 363.6 and let's see if you don't see a trust. Ladies and gentlemen, let me show you the trust. Would you like to see the trust? We're just going to read it first. Minor. Notice this minor is all capital. Okay? Minor means an individual under the age of 18. Now, a minor and an adult can be the same. We're going to see that in a minute. But a minor and an infant are exactly the same. Why? Because we will agree. An infant is not no minor. An infant is not that thing in a manger that sits up there and eats in the trough and the water trough and the food trough of animals. That's not the infant we're talking about. You're not talking about the baby Jesus? No, I'm not talking about no baby Jesus. I'm talking about infants and minors, that they're one and the same. No, they're not. An infant and a minor are not the same. An infant and a minor are the same thing, ladies and gentlemen. How do we prove that? Because an infant and a minor, we can both agree on this, is an individual who is under the age of 18. Oh, okay, yeah, that makes sense. They're both under the age of 18, so yeah, you're right. They're both the same thing. All right, but an infant and a minor, shut up. An infant and a minor are the same thing according to this code. They're both under the age of 18, so we can all agree that an infant and a minor, according to this code right here, are both under the age of 18. So a minor is an individual or an infant who is under the age of 18. Just that simple. Just get it, okay? Because you're going to want to think outside the box and get away from the box. The box is there to trap you. Stay away from that box, okay? Now let's go to the second line. The term, legal terminology, the term, lowercase, the term minor is also used to refer to an individual who has attained the age of 18 years, but has yet to take control of the securities contained or held in his or her minor account. Okay, hold on now. So a person who's over the age of 18 is still a minor because they haven't gained control of their securities that's being held or contained for them in their minor account. How do you know they're being held for them? It doesn't have to be held for them. Okay, we'll find out. Let's look. A minor account means an account that a custodian or trustee controls on behalf of the minor. So it's being held and controlled on behalf of the minor. Wait a minute. Hold on. Let's go. That is linked to the custodian's primary account. Wait, hold on, y'all. The custodian, if it's the state, what's the state's primary account? Isn't that what the state treasury? What's the United States primary account? Isn't that the United States treasury? Then shut up. Because I promise you, we got it. Hold on, because we're not finished, ladies and gentlemen. Now notice, the minor account here is lowercase, but this minor account is capitalized because it's the beginning of the sentence. This minor is capitalized not because it's the beginning of the sentence. This minor is capitalized because it is a proper noun, or a pronoun, or a con noun, or a negative noun. Anyway, minor account means an account that a custodian or trustee controls on behalf of a minor. Pay attention so that you get it. This makes this a trust relationship. What do you mean it makes it a trust relationship? I don't see no trust in there. Well, there are 4 elements to a trust. 2 of the main elements are there must be intent. What's the intent? Well, the intent is to hold the securities of the minor until he reaches the age of 18 and takes control. That's the intent. Now, who holds the security? The custodian on behalf of the minor. So but what's the value? The securities. So those are your three elements. Well, you just gave us two. You didn't give us, you just said somebody who controls it on behalf of somebody. Pay attention. A minor account means an account that a custodian controls on behalf of a minor or holds. Ladies and gentlemen, that makes the minor the beneficiary. That's right. The minor is the beneficiary. You are the beneficiary of that account. So that's the third element of a trust. And that there must be a trustee. Hey, that custodian, isn't he a trustee like you said? That's right, the custodian's a trustee because he's holding something on behalf of another for the benefit of another. That makes him a trustee. Isn't that interesting, huh? So you have the four elements of a trust right there. Now, how do we prove this is what they're doing in the courts? How do we prove that the courts are dealing with minors? Well, let's do the attorney thing. Remember, an attorney can only deal with four different creatures. A minor, infant, juvenile, or incompetent person. Minor, infant, juvenile, or incompetent person. Remember that. Those are not four, that's one. Minor, infant, juvenile, or incompetent person, same thing. An insane person, a decedent, and finally, a corporation, estate, trust, blah, blah, blah. That's an attorney. Those are the four things an attorney can deal with. Four things. And the reason why he can deal with you, because you're not considered a natural person, you're considered a minor, a statutory citizen, because why? It's a legal term. That's why they can appoint an attorney. And every time you get an attorney, the attorney cannot deal with you under equity. They'll say an attorney can represent you under equity. No, he cannot. He cannot represent you in your attaining the age of majority capacity. Ladies and gentlemen, that's why SATCOM, the first thing we did was we created a POA, attached a birth certificate according to the principles of the Minnesota court rule, which says that when an individual attaches an affidavit to their birth certificate showing that they have ownership, they are to be construed as having attained the age of majority. Now, hold on. Even though that talks about land titles, we're looking at the principle of Minnesota Court Rule 220. We're not looking at the exact language. And for those of you ignorant people out there who don't understand that a birth certificate is actual proof of title to property, land property, I can't help you. That's not what this video is about. What we're trying to get you to understand is every case in court is dealing with a minor infant estate. They're handling a trust. They're administering a trust. Now you can prove that they're administering a trust because why? You can prove that they're administering a trust because you are, pay attention to this phrase, you need this phrase. You cannot exercise any of your rights without this phrase. You are the beneficial, equitable holder of title. Some people will say you're the beneficiary, or you're the equitable title holder, but you're the beneficiary and the equitable title holder. So beneficial, equitable title holder is who you are. Beneficial, you're a beneficiary, equitable title holder. That's you. The courts operating in their administrative trust capacity cannot deal with you in your beneficial, equitable title holding capacity. Why? Now remember, beneficial equitable title holder, because all you got to do is say, hey, here's my affidavit that's been placed on the public record, and I have it notarized, which says that I have attained the age of 18, and I have gained control of the securities held in my account, because one of the main securities in my account is me, and I've been controlling me ever since. Do you understand? And then you can work on gaining control of the other securities. All right, now, got to get all that out. But no. We got to still prove to you that the courts are handling trust. So on our website, on satcom911.com, satcom911.com, satcom911.com. Anyway, at Satcom, you will find this document. It's called the Emancipation of the Infant Estate. Okay. The emancipation of the instant estate of an infant may relieve him of his obligation to his parents and may have other results, but does not remove all the disabilities of infancy. Why? Because he hasn't gained control of the securities held in his minor account. Okay, give me 1 second. I got to pull up another document. It ain't this. It ain't this. That's the wrong one. We got to go. Uh-oh. Where is it at? It's supposed to be here, but it's missing. So we got to do emancipation. Emancipation, what's your nation? I'm going to get you there if you're very careful. If only people knew what the Civil War was really about. The Civil War was about this infant stupid estate thing. Everybody is going to say, no, it wasn't. It was about slavery. It had nothing to do with slavery of quote unquote colored folks. It had everything to do with the enslavement of man, saying that these people were, pay attention, minors, infants, when they were grown adults. See, in order for you to be a minor and be above the age of 18 means that someone is holding you incapacitated. They are restraining you of liberty. So, watch this. Where'd you go? It was right here. Oh, it's still popping up, so I gotta wait for it to finish. Whew. There it is right there. This is where I got this from, okay? False statement, criminal resource, concealment, anyway. We don't care about the elements. You know what we care about? Let's make this, we're looking for exclusive jurisdiction. Generally, an infant may acquire property rights, and he or she cannot be deprived thereof except as provided by law. Yeah, infant and minor law. Generally, an infant may acquire property rights, but he or she is not regarded as capable of managing his or her own property because he's an infant, he's still a minor. Hence, the law does not entrust him or her with the custody or control of his or her estate. Now you understand? Corpus Juris Secundum 163. That's Corpus Juris Secundum 163. An infant may not be deprived of his or her property right except in modes as provided by law. What law? Administrative law. See, also an infant has no legal capacity irrevocably to abandon his or her property rights. So you cannot waive your property rights. You just have to express your trust in court. Okay, intermeddling with the estates of infants. Anyone who intermeddles with the property of an infant without authority is liable therefore. That means the courts. Once you express the trust, once you notify the court. Now look, I'm not going to talk to you about trust law. I'm going to let you go and review the information on trust law from the people like Mr. Jonah Bay. Didn't mention him earlier and I was supposed to, so I apologize because I have a lot of respect for Mr. Jonah Bay. I've never met Jonah, but I do respect Jonah. And Mr. Yusuf L. I've never met Mr. Yusuf L. We've communicated once, and it wasn't in the best of circumstances, but I still have a lot of respect for that young man as well. Please understand, ladies and gentlemen, they get this, okay? Pay attention to this section right here. 167, jurisdictions of courts over the estates of infants or minors. The jurisdiction over the estate of an infant is inherent in equity. Hold on. Wait a minute. Hold on. How is the jurisdiction inherent in equity? Because the reason why it's inherent in equity, because it's a trust. They're holding the infant estate in trust. It's all equity, ladies and gentlemen. Everything is equity because that's all the courts are doing is dealing with infants. Okay, if you only understood equity, if you only understood trust, that they go hand in hand, that's your research, people. Look, there is a video. Not the show me love. Why don't you show me love? That's not the video. We can go to this video right here. It's on YouTube. This guy, he's from Britain, the UK. And being from Britain, he did a video. And his video is rather poignant. And so it is asked that y'all do some searching and researching and understanding of the information. So we're going to let them talk. Shaving! I'm not even going to try. Express Trust Declaration. Now listen to
In
him.
this lesson, we're going to have a look at express trust, specifically declaration. Now, in order for an
The unique
express
thing,
trust to be properly
hold on. The unique thing about this young man is he not only goes through it with you, but if you go to YouTube, you want to type in trust law hyphen express trust hyphen declaration, and you'll pull up this video. This young man has a $10 course on his website. Okay? If you pay for it, knock yourself out. If you want to send it to me, knock yourself out. But nonetheless, he has a $10 course for giving this information to people. I find the information that he's discussing is 100% accurate. So far, everything he says is accurate. And so I got to give him credit for that. Let's let him talk some more.
declared, it must be in either words or in writing. And this was primarily mentioned in the ratio of the seminal case of Ray Vanderwaal's trust. Now, besides this, what you need to understand is, as per Gissing and Gissing, what is important is not really what the speaker or the person who is actually saying the words meant, rather what the reasonable bystander thought. So what's important to understand in relation to the declaration of trust being in words or writing is that it's an objective test based on the reasonable bystander. Now, subsequent to this, there are several other requirements which need to be fulfilled as well. Firstly, you must show that the settler intended to create the trust. What is meant by this is whether the settler wanted to legally bind someone else or a third party to be trustee to the
Hold on. Do you hear that? You must show that they intentionally intended for somebody to administrate the trust, to be bound. Minor account means an account that a custodian controls on behalf of the minor. That is linked to the custodian's primary account. The government, with the New Deal under FDR, took everybody's accounts and held them in trust. That's what the New Deal was about. That's what the Social Security Trust Fund is all about. That's what the Treasury Trust Fund is all about. Sorry, I had to sneeze. So now we can show that there was intent. Told you, one of the elements of a trust. Let's
trust.
continue.
Have a look at McCormick and Grogan, a case which is available in your case summaries along with both Ray Vanderwaal Trust as well as Gissing and Gissing.
Now, look, I'm not guessing. You're so funny. Anyway, ladies and gentlemen, I just want you to understand, this is for the UK. This is for Britain. But trust law is the same throughout the world. Equity is the same throughout the world. Why? Because they've turned equity into an administrative tool. Now, some people say equity's always existed. No, equity hasn't always existed, not in the format it's in now. There are two forms of equity. You have the biblical equity, where it was established by God when he came up with the law that he bestowed upon man. What do you mean? What law? The law, every tree of the garden you may eat from to satisfaction, but as for the tree that is in the middle of the garden, a restriction, you may not eat from it. So every tree of the garden, that was the benefit, but he told him that he was to cultivate the ground. He was supposed to take care of the earth. Adam was both trustee and beneficiary. Well, his actual children were beneficiaries, but he was the trustee. He was to take care of things. He was to make sure the law was obeyed. And he breached the trust. Thus, he had to suffer the penalties at equity. That's why he was sentenced to death. Sorry, that's where the whole principles of equity come from. Sorry, hold on. Let's let you. But the equity they use today is an administrative equity. It's not the same equity, people.
To get a better understanding of this first requirement. Secondly, the rights must be identified. It cannot be ambiguous. Thirdly,
hold on. Let's find out if the rights are identified right here. Remember, we're not looking at no other code. We're just looking at this section right here. The minor means an individual, and what does he have a right to? He has a right to take control of the securities in his or her account. Okay, that's what he has a right to. He has a right to attain the age of 18. Okay, that's what he has a right to. How do we know this? Because a minor account means an account that a custodian controls on behalf of the minor. Okay, and here it says taking control, who has yet to take control of the security. He has the right to take control of these securities. He and she. Okay, and he has the right to attain the age of 18. A minor is an individual under the age of 18. He has the right to make it to 18, but if he makes it to 18 and he don't gain control, he has the right to make it to 18 and then gain control. So there you go. Let's continue. Number 3.
The beneficiary must be identified.
Hold on. We already talked about the equitable beneficial interest belongs to the minor. Why? Because he is the beneficiary. Why? Because it's being held for his behalf. Controls on behalf of the minor. Gain control of the securities in his or her minor account. The account belongs to him. Somebody is holding it, or entrusted is someone with his securities. So it's being held in trust by someone else, a custodian. Okay, let's go. I know, he's a genius. I know. Let's continue.
Now note, during our introduction and outline of this subject, we identified that there are 3 key players. You have the settlor, the trustee, and the beneficiary. In some occasions, as we will look at in future lessons, there can be a situation where the settlor and the trustee are one and the same. Fourthly, the shares must be identified.
Wait a minute, where are the shares in this agreement right here? What are the shares? Okay, those are the shares. There you go. All right, let's find out what's the thirdly, because he's talking about fifthly.
Fifth, the trust must be workable.
The trust is workable because the minor has the ability of attaining the age of 13, and he has the ability of gaining control of the securities in his account, and the custodian links his account with his primary account. So he is capable of doing that. So yes, it's workable. Work it! Come on, work it good!
You must be able to effect the trust properly, and we will look at this a bit later on as well. And finally, sixth, the trust cannot last forever.
The trust, make it last forever and ever. Don't let our love it bad. Sorry, Key Sweat, yeah, I love you, bruh. All right, ladies and gentlemen, so that you know, this doesn't last forever. It only lasts until the minor attains the age of 18 and gains control of the security in his account, i.e. a trust relationship. Like I said, we weren't seeing it before. We were looking at this dealing with the Treasury Direct account, and we were headed towards it and everybody kept talking about Treasury Direct, and I'm like, this has nothing to do with a Treasury Direct account. That's a separate account. That's a minor account. The Treasury Direct account is not the primary account. I've been saying that to people, but nobody's been listening to me because I've seen it already. But what I didn't see was the trust until today. Okay? That's when I saw it. But I didn't see it by looking at it. I saw it by looking at it in my own mind. Okay, this is what I explained to people. I remember I was on vacation in PR, and there was a young man, and he was asking me, I said, this is the way my mind works. If you remember the movie Minority Report. And he said, yeah, I remember that. I said, well, you remember when Tom Cruise was taking his hand and moving things in the air and sliding things over as if he was actually working on a computer that was hanging in the air? I said, that's what my mind does. Ladies and gentlemen, while I was sitting down thinking about all of this, thinking about trust, thinking about, talking to the court and making sure they understand that I'm expressing the trust, and if they ask this question and that question, I'm putting all these pieces together, and that's when this came together. Because everybody keeps saying, but you got to prove that the trust exists, because they'll say they don't see no trust. There you go. There's your proof that the trust exists. And all you got to do is understand what's being said here in this video. And you can prove the trust exists. You can prove every element of a trust. And then you go and you take and you listen to this video by this young man 3 or 4 times. It's only 11 minutes.
It must be finite in nature, either defeasible or contingent. Now, we need to identify at this juncture whether in fact a trust was created, because you might have these requirements in place, but ostensibly it might not necessarily be a trust. So how do we identify this? Firstly, if it is absolute, in other words, if it takes the form of a gift, that means that there is no binding trust in place. Now note, much like the words and the writing that we mentioned earlier, mere intention that another person, a third party should benefit, a beneficiary should benefit, is not enough. Have a look
Not
at Jones
enough.
and Locke, another case available in your case summaries. Now conversely, if a particular
Conversely,
transfer was to hold on behalf of another, for instance a trustee let's say, then there is a trust instrument. So what you need to realize is that besides this beneficiary component that we've been discussing throughout, the trust instrument requires primarily a settlor and a trustee as well for that trust bond to be created.
ladies and gentlemen, let's prove that there's a trust bond relationship here. The minor account means an account that a custodian controls on behalf of the minor that is linked to the custodian's primary account. And when a minor turns 18, that custodian must release or relinquish control to the minor. He's bound. Why? Because it's linked to his account. He's now bound by that. He has a fiduciary, trustee, custodian relationship. Told you. All the elements of a trust right here in this one little code. Oh God, he is a genius!
So how exactly do we find intention? Well, the most obvious and the most straightforward method of doing so is by the use of the words. So for instance, if...
Okay, now you guys can go watch that video because there's no reason for me to play the whole thing. We already talked about the intent. It was government's intent during, especially, we're not going to, the intent is right here, that the account will be controlled on behalf of the minor until he reaches the age of 18. And if he reaches the age of 18 and doesn't gain control of the securities held in this account, it will be controlled until he does. That's the intent. And that it would be released to him upon attaining the age of 18 and gaining control. And it would be held by a custodian. All the elements of a trust right here. Ladies and gentlemen, some of you who are watching this are not going to want to give credit to me, and you're going to want to take away from the information that's here because of either jealousy or stupidity. And don't worry about me using the word stupidity because that's your own fault for being so stubborn. Because you don't want to see it because it's coming from me. Because you just, and that's what you're going to do. You're going to want to blame it on something I did. And that's going to be to your own stupidity and your own detriment. That's right, I say stupidity because it's a stupid person who doesn't want to listen. It's a stupid person who will stab themselves in the foot just to avoid putting shoes on. In other words, you want to avoid taking in the information because you don't like the way it's being delivered. That's your ignorance. That's your stupidity. That's your problem. But the problem is you can't get around the information because nobody else has brought this out. To this present day, go anywhere on the internet and see if anybody throughout the history of the internet, go in any book and see if anybody's brought this point out, that this is the elements of a trust, all within this one section. This proves that there is a minor account. This proves there is a minor trust. This proves that there is an account that they have with our names on it. We just didn't know how to express the trust. Here is the expression of the trust. People, go back over the video. Express the trust. And guess what? Whatever comment, whatever thing they say, you make sure you tell them, sorry, you don't have the jurisdiction anymore. This is exclusive jurisdiction and equity. Let's prove that, and then we're going to cut this video short, then I'm going to go put it up online so y'all can have it. Okay? Is this the one? No, this is the one. This is the one. No, that's not where I'm supposed to be. I'm supposed to be back down here to 67. Now remember, it says jurisdiction over the state of infants is inherent in equity. Okay? But it may also be vested in constitution or statutory provisions in particular courts. The institution of proceedings affecting infant's property makes the infant a ward of the court. Okay, the institutions of proceedings makes the infant a ward of the court, which has broad powers and the duties to protect his or her interests, which is why you have to put on the record you're having attained the age of 18. Pay attention. That's why the affidavit. That's why the birth certificate, because it proves you have attained the age of 18 and are no longer a minor. You have attained the age of 18. So where does their jurisdiction lie? Once you express the trust, people, that's how you gain control. Because a trust may be created even without your knowledge, but now you have knowledge, now you can explain the existence of the trust. All you got to do is say the Treasury Trust and the Social Security Trust. That's all you got to do is say. You don't have to prove they exist. Oh, I'm sorry. You don't know about the Social Security Trust? Anyway, my bad. I'm sorry that nobody informed you of that, but let's talk about the minor or the infant trust. You see, you're considering me as a minor, a ward of the court. I'm not a ward of the court. You don't have a duty to protect me because I have attained the age of 18. I have the duty to protect myself. I have the broad duty, and I have not surrendered that duty or surrendered any rights to you. Pay attention so that you get it. Primary jurisdiction over the estate of infants may, under constitution or statutory provisions, be vested in probate, county, district, or other specified court. Hold on so that you get it. Primary. No, you tell the court that exclusive jurisdiction, because this is a trust. That's how you pull it out of this primary jurisdiction, or concurrent jurisdiction is what it's called in other areas. The jurisdiction can be exercised only when the court has acquired jurisdiction as to a particular infant or subject matter. The commencement of proceeding affecting the infant's property vests the court with jurisdiction over his or her estate. You have to prove you're no longer an infant. See, this is where the court act as guardian. It says, pursuant to which the court acts as loco parentis, or as guardian. It's called sovereign guardianship. And the infant becomes its ward. It is the duty of the court to safeguard the infant's property or property interest with great care. They're holding it in trust. And to discharge its duty, the court is not bound by the pleadings of counsel and may act on its own motion, which the court does all the time. That's why they can ignore you. Okay? After the jurisdiction of the court has attached, the court has broad and comprehensive and plenary powers. No, you don't want plenary. You want chancery over the estate of the infant. It may adjudicate the rights and equities of the infant and the property, and it may cause to be done whatever is necessary to preserve and protect the infant estate. However, the exercising of such powers must be tempered with reasonable limitations, i.e., express the trust. People. Therefore, the court cannot act in violation of constitutional or statutory limitations of its power. Express the trust. They have no jurisdiction over trust. Trust must be handled in equity. Equity has exclusive jurisdiction. I want you to pay attention. I want you to pay attention. Limitation of its powers are to permit the impounding of the infant's funds for the creation of a trust to deprive the infant of the right to absolute enjoyment of the funds at majority. I told you, it's all right here. This document is called a petition for the emancipation of an infant. It's on the website under the PDF forms. I will put this under the arbitration files today. An infant is not competent to waive the statutory requirements enacted for his or her benefits and protections with respects to the manner in which jurisdiction of the court is exercised. Ladies and gentlemen, that's why you can't come in as an infant. That's why you must put the affidavit on the record, which is why some people have been having some success and didn't know it. I can only tell you what I tell you, okay? But I promise you, that boy's a genius! I gotta go, ladies and gentlemen. I could sit here and talk more and more, but then you would miss the point. Go back over this video, listen to it, get through the antics, get through the techniques of teaching, and understand the information. I promise you, if I could not have done greater than this, I give all credit to the God that I serve, because He's the one who has allowed me the ability of being able to see things the way I do, which is definitely different from the way everybody else do. And I dare anybody to argue with me that the trust is not expressed in just these two paragraphs. I dare you. and then I'ma cry and go home and boo-hoo. Bye-bye. Adios. Arrivederci. Sayonara. Que sera, sera. You know what I mean.